At the outset of today's hearing, I made sure to bring Mom with me, and I placed her right next to me from the speaker's pedestal. And I told the court that this is going to be a moment of tribute for her, as well as Supreme Court jurist John Paul Stevens. Both of these people were exceptional pioneers. Both of them are smarter than I am. I just had a better education than my mom, that's all. So I make do with perseverance, and she had brains and perseverance until she didn't because of frontal lobe dementia. So please, people, if you know anyone affected with this disease, do whatever you can to help them and keep them comfortable and loved. All right, here with KingCast Justice, and I've just finished my oral argument against Facebook in King versus Facebook, 19 Civil 1987. And that issue is, of course, the DCA Communications Act and various things like that. But first, I'm going to get from this observer who does have some legal experience, where I met him at Case Western Law School 35 years ago. I don't know, 30, something like that, 1990. All right. Mr. Trent Berry, you're a resident of San Francisco.
Yes, I am, sir.
And local software developer and musician. Mm-hmm. And I have a question for you.
Sure.
What do you think happened in there today, and how did I do?
I thought you did outstanding. I thought that you called them arguments. I called them electrifying arguments. Here's the bottom line, kids. For those of us that don't know the details, the DCA has been used and abused by monolithic corporations to suppress free speech. Regardless of how this case shakes out today, I am very glad that I was there to witness Chris King's authentic, unique, and in some cases unnecessary, novel arguments that really showed the true interpretation of the DCA and how it should not be used as a baton, or should I say a riot police baton, by monolithic corporations just so they can be easy and cheap in terms of their interpretation of free speech. Chris King struck a blow against that today. It was awesome. I absolutely salute you, sir, for that, and I'm looking forward to a proper and favorable resolution of this case from the court.
Indeed. All right, sir. You'll catch me.
All right. Now, for what really matters, tell me what you felt about today and how you think it went.
I did good.
I thought you did. I thought you rocked it. I thought you rocked it, actually.
Mama's proud.
Yeah.
Mom, that's for you.
Yeah.
You and Libby, you guys, love you. So, yes, what happened today was I was able to run through the litany of other cases and legal authorities, including Facebook's own amicus counsel, that said the courts have been getting it wrong all these years with respect to analysis of the DCA, 47 U.S. Code 230, okay? It's not a blanket immunity. And I pointed out the fact that this was done, to help a fledgling internet industry 25 years ago. Well, Mark Zuckerberg is worth $85 billion now. He's no longer a fledgling internet anything, and that, he doesn't need protection from anything. We need protection for people like Mark Zuckerberg, okay? So what it came down to in the end was Facebook asked that this case be dismissed with prejudice. And the court, I was explaining to him that you could make a change right now in all of this abuse that's going on. And I showed him clearly where a white woman could call herself a cracker, but I can't call myself a nigger. I pointed that out and I said, look at the hate speech, rationales and what that means. And so clearly I'm not engaging in hate speech, neither is she. But I'm the one that can't say that. So I don't think he's necessarily ready to break with all the precedent. He listened to me on the Darna case, and Facebook hates that case because it supports what I'm saying.
Yes, and of course they had to sheepishly refer to that case as a outlier, because they knew that was the crack in the armor.
It is a chick in the armor, it is. And so I wanted to expand on that, and the judge, he's kind of wavered on that one, but he says, if I, don't grant their request to, for dismissal with prejudice, is there another set of facts that another set of operative facts that you could bring forward?
And tell us about that set of operative facts, because it's very revelatory, isn't it?
Yeah, yes, it is. And I noticed it. Okay, so I explained to the court. I says, Your Honor, here's the thing. I said, I got two blogs. Well, I got many blogs, but the two that are most relevant are, I've had Chris King's blog ever since my mom told me to get one, I don't know, like 2005, something like that. And then I've got How to Sue Facebook blogspot, okay? Well, everything that's on this blog is on this blog, but not vice versa, okay? So Facebook has blocked me. Originally, they blocked me from either of these, okay? Subsequently, they allowed me to post Chris King's First Amendment page, okay? But not How to Sue Facebook, okay? Well, that tells you right there. It's not about the content.
Yeah, because in fact, the content is synonymous on both.
The content is absolutely identical. The posts are identical.
Content
So what
is
that's about is a retaliatory breach of contract. Because if it's acceptable for me to put it up there as Chris King's First Amendment page, but not acceptable under How to Sue Facebook Blogspot page, then it's not about the content.
Indeed.
It's about them hating on this nigga right here. That's what that's about.
All right.
That's all it, man.
Bang.
Bang.
All right, good luck to you,
Bang.
sir.
Thank you.
Well done today.
Yeah. And black voices still matter. I'm out. Yeah. Where's that flag? There it is. And justice for all. Now. The original plan was for Facebook to go ahead on and become a nation state. And that's what they're doing. But they're doing it without any sort of guidance, without any sort of, what can I say, safety precautions. You know, there's no accountability. So, in the real nation state, which is the United States of America, we have a First Amendment to the Constitution, okay? And you cannot stop people from speaking unless they violate that, all right? So many of us are arguing that Facebook should be on a First Amendment standard regardless. So, you know, hate speech would fall out of the window unless you were actually threatening someone, okay? But, Your Honor, even if we don't go that far, even if we just say, wait a minute, legal scholars are calling for an objective viewpoint, an objective analysis of how the rule is being applied to censorship, okay? If we go by that, we can clearly see, Your Honor, that Facebook is not following its own dictates when it comes to hate speech. Hate speech says that I, as a black person, can self-referentially reference myself as a nigger. Just like that white woman did, I just showed you, Your Honor, who calls herself a cracker. There's no difference. Those are the two most approximately similar terms that blacks and whites could hurl at each other, are nigger and cracker, okay? And so we clearly see that they're not adhering to their own policies. Now, the question for you, Your Honor, when you go back to deliberate on this case, is whether or not you're going to continue to get it wrong, as all these other courts have, or will you look towards some objective standard that's being urged here to recognize that this law has been outmoded for quite some time, and that you have the authority to help make a change without engaging in unwarranted judicial activism. That's all I ask of you today.